And it's especially true when they're looking backwards, applying the hindsight bias to that also, because now they're looking backwards at that, saying, well, I would have done that differently. So you have a combination of defensive attribution and hindsight bias and the egocentric bias. So think about that when you're looking at these people who are similar to your plaintiff. So now the other aspect there, I just flipped by, was the intensity factor. The more serious the harm to the plaintiff, the more likely they are to apply defensive attribution because they want to push it further away from them, okay? The next thing is I got that, okay. This is very true. I'm so excited to go on jury. When's the last time you ever saw that? Okay, so the self-serving attribution, jurors who attribute causation based on what serves their own perceived best interest. This is the target. This is what the defense is looking for. They're looking for tort reformers. And how do they reach out? They raise the issue that their own best interest is to not award large money damages to a plaintiff because what? It's going to raise their insurance rates. It's their own perceived best interest. So these are the people that say, I don't care if he's paraplegic. I don't care. Maybe they were a little negligent, but what the hell? I'm not going to raise my insurance rates. And so these are the people that the defense lawyers look for and thrive on. So coming back to what Kahneman talks about too, the power of choice. The spotlight theory, you heard this morning about the availability bias. I think the availability bias is such a huge, huge advantage for us, which is that jurors will focus in deliberation where what I call the spotlight theory, jurors will focus in deliberation where the spotlight was placed during trial. What that means is, and the reason it's an advantage to us, because we get to place the spotlight. We get to decide where to put the emphasis. So that's why you don't want to give too much information about your plaintiff. You don't want to overtry your case with an excessive amount of information because the spotlight theory. When you go into deliberation, the thing that is talked about least in a jury room, this came out of years ago, out of a lot of survey of actual jurors in real cases. The thing they talk about the least is physical pain, mental anguish, physical disability, physical disfigurement. I'm not saying they don't talk about damages. I'm saying they don't talk about injuries. And the reason they don't is because a lot of times we don't prove injuries. We don't go into detail on proving injuries. We don't go into the detail we need to go into to prove the physical pain and the mental anguish and the physical disability and the physical disfigurement. So you need to put the spotlight on this. Every element of damage requires its own individual body of proof. So we take the element of physical pain and suffering. We'll go into the war room and we'll write it right up here. Physical pain and suffering. And then under that element of damage, we'll write the names of we'll write our witnesses. We'll look at our body of evidence. We want an entire body of evidence devoted just to physical pain. And you get expert testimony, lay testimony, documentary evidence, demonstrative evidence, and then admissions that you've already got, things that you've already got in. But then we'll look at that, and then we'll make a list of every witness that's has anything to say about physical pain that supports our physical pain proof. And what is that going to be? We'll look at every document that supports physical pain, and we'll put together that entire body of evidence. When you do that, that's the availability. We make available to the people who are going to determine the value of your case the data, the evidence about the injury, what your client has to live with for the rest of their life if you got a serious injury case. And then remember this, coming back to compared to what? So when we prove up when we prove up these injuries and we make this evidence available, we're proving three things. There are three elements. Compared to what? What was the plaintiff's physical life before the injury? What was their life like before? What is their life like today? And what would their life be like for whatever period of time that they will suffer damages in the future? Because just putting evidence in abstractly doesn't resonate nearly as soundly or nearly as strongly as putting it in comparing to what they were before, because that's the real measure. So the spotlight theory, we get to put the spotlight where we want it. So with that in mind, going back to what we talked about, we want to put the spotlight on the creation of circumstances, the bad choices that were made by the defense that caused this whole tragedy in the first place. There's your spotlight. We want to put the spotlight on the personality of the 18-wheeler driver, the adverse party, whoever the defendant, whoever the bad guy is. We want to put it may be a bad corporation. Gee, there are some. You want to put the spotlight on whoever the person is that has responsibility at that corporation. So that's the spotlight. And then we want to put, to the extent possible, without overdoing it, we want to put the spotlight on the good personality, the good characteristics, the real integrity of our plaintiff. And the fact that our plaintiff did not contribute to the circumstances. Our plaintiff was not a contributor or a creator of the circumstances. Our plaintiff was what? Reactive. Our plaintiff was reacting to the circumstances created by this defendant. So that way, with the spotlight theory, you take into account the attribution biases, and the best, this is what I love to do. I love to go to the blackboard, I go to the whiteboard actually in my war room, and we'll write choices. We'll write choices. And we put up every choice that the defendant made that contributed to creating the circumstances that caused this tragedy. And we'll put all those choices up there. And that's a good starting point. So now, when you get your choices up there and you look at the conduct they did, because of what Kahneman tells us about thinking slow and thinking fast, it's the unconscious mind. It's what I've been talking about this for years, about the difference between the unconscious mind and the conscious mind. When you get those defendants' negligent conduct up there, the bad choices, you reframe the defendant's negligent acts into positive actions. You don't say the defendant failed to do this. You don't say the defendant failed to do this. You say the defendant chose to do this. Okay? If you've got a medical negligence case, it's not that the doctor failed to do this. It's that the doctor had four choices. He could have done A, and you explain what A is and what its purpose is. This test was done, how it should have been done, and if it had been done in this case, what it would have shown. He could have done this. No, second choice, but he chose not to do it. He could have done this, third choice, but he chose not to do it. He chose instead to send the patient home with literally an aspirin and say, call me if you have any further difficulty. Well, the patient didn't have the opportunity to call him because he was dead. So those are choices. Frame these things in terms of positive choices. Why? Because of the unconscious mind, because of what Daniel Kahneman refers to as the fast thinking, the unconscious mind, because those resonate in the unconscious mind, but there are things you need to know about the unconscious mind. The unconscious mind does not process negatives. So when you say, do not do this, the not doesn't register in the unconscious mind. The not has to be processed in the conscious mind. So you're wanting to communicate with the unconscious mind, so you don't want the jurors to have to think and process all these things that the plaintiff failed to do. Well, let's see, he failed it. That's got to go up here. No, he chose to do this. boom, it's in there. It doesn't require any processing. That goes into the fast-thinking mind where the decision-making takes place. So that's why you rephrase it. You go over the multiplicity of defendant's choices. You go into the absence of the plaintiff's choices. The defendant's conduct left the plaintiff with no choice, or left the plaintiff with the only choice they had, which is exactly how they responded and what they did. So positive outcome, positive outcome, positive outcome, chosen by the defendant, tragic death. So the more choices, again, there's an exacerbating factor in there. The more choices you can show, the more likely you are to increase the damages in the case. So more choices, larger awards, irritation factor. Jurors imagine an alternate scenario that changes some surprising, unusual, or abnormal event. They will try to think up. They will try to think up alternative scenarios that would change this. So give them those. Go over the alternatives. Cover the alternatives so that they can't say, well, you know what might have happened was this. We hear this so much in focus groups. Well, if you leave it to them, well, what might have happened was this. What might have happened was this. No. Go over the alternatives. Go over what the choices were and show that they didn't happen. Show that that was not a choice. Close the door. Cover it all. All right, the hindsight bias. The jurors view the outcome as having appeared inevitable. You have to show them that this outcome was not inevitable, because if it was inevitable, it's not the defendant's fault. So you have to show why it was not inevitable by showing the choices they had that would have avoided the outcome. We're starting to hear a theme resonate here about choices. So the purposive attribution, defendant's bad choices. Reactive attribution, bad conduct by the defendant, plaintiff left with no choices. So when you're communicating with the fast-thinking mind, the unconscious mind, you tell your story. This is important, as opposed to everything else I've said today. You tell your story in the present tense. You tell your story in the present tense. You tell your story in the present tense. Why? Because the unconscious mind, which is where the decision making and the processing takes place, does not resonate in the past or in the future. The unconscious mind reacts and processes only occurrences in the present tense. So when you write your story, tell your story in the first person. But that's a whole different speech, but just take my word for it. Visual images, to reach the unconscious mind, you use visual images. You use colors. You create everything that you can. You use every sense you can invoke. That's what resonates in the unconscious mind. And then the other thing about the unconscious mind, this is why metaphors, similes, and rhetorical devices are so extremely important. Because a metaphor, straight to the unconscious mind, doesn't have to be processed. So that's why our metaphors, rhetorical questions, same thing. What Paul's just talking about. Those things are processed in the unconscious mind, which is where you want them to be. So let's talk one last thing. The one last guy we haven't mentioned, aside from Kahneman and Lee Ross, is Milton Erickson. Milton Erickson was the father of a lot of this. He's the guy who taught us about the importance of verbal, nonverbal, and vocal communication, and how you have to have a synthesis between your verbal story, your nonverbal story, and your vocal story. The vocal is so important because, as I've told you many times, the words we use, the verbal is only 8% of the delivery of your message. The nonverbal communication is 55% of the delivery of your message, because why? Back to Kahneman now. All that stuff happens in the unconscious mind. All that is being processed in the fast-thinking mind. The vocal, is 37%. That sounds like a lot, but you know, one of the things, the vocal is so important because, for one thing, sincerity. Your sincerity will resonate out of the vocal as much as anything else, out of the vocal and out of eye contact. It's where the sincerity. And you have to be sincere. I asked Larry Smith, our dear departed friend who wrote much of this stuff, I said, Larry, what is the most important one single thing that you can tell me about persuasion? What's the most important thing? He said, sincerity. If you can fake that, everything else falls in place. So now, what Erickson taught us was, if your vocal and if your nonverbal actions are not in accord with the words you're using, the nonverbals are going to prevail every time. And if the nonverbals prevail, that means they're rejecting your words. That means the words you're using are a lie. Okay? So that's why all this is so extremely important. Have I got 1 minute? Oops, I don't. Okay, so that's absolutely everything I know about Kahneman and all this sort of thing. So I'm going to tell you to go enjoy the rest of the convention. I hope you've gotten a lot out of this, because we've waited a long time to put together the Kahneman program, and I hope you've gotten a lot out of this today, and the tremendous job that was done by the speakers. So we hope we've said something today that will help you help your clients. Thank you very much.
Thank you very much, Howard. As usual, terrific.